Let's bring in distinguished professor at Thoreau University, Thane Rosenbaum, to give us some legal analysis. Great to see you, Professor. Your take on the court's ruling here?
Not surprised by it, Chris. For a number of years now, the conservative majority on the court has explained their skepticism about racial preferences. To them, this has always been an equal protection argument out of the 14th Amendment. It's ironic, right? Equal protection, the 14th Amendment, arises out of the Civil War so that everyone could be treated equally. And now Asian Americans have been using the Equal Protection Clause in order to gain their rights because they believe that they had been discriminated against and treated unequally. So the Supreme Court just basically bared down and said, look, we've already said you can't use quotas. That was years ago. We said you can't provide additional points in a point system. You can't create a percentage system. And now you can't check a box. It had gotten to the point, Chris, where it was simply a factor like hockey, like music, like your parents going to school. Race was just another category. And they're saying, well, it's not like hockey because hockey is based on your ability to play hockey. It's not based on the color of your skin. It's not colorblind unless it's not colorblind. And so Chief Justice Roberts once said, we'll stop discriminating on the basis of the race when we stop discriminating on the basis of race, which means that we have been invariably discriminating on race in order to favor persons of color. And in this case, it backed up in a very interesting way because Chinese Americans said, on basis of merit, we deserve to be admitted, and we are being discriminated against under the 14th Amendment, was there to protect African Americans, and it should protect Chinese Americans too.
Well, not only Chinese, all Americans. Race should not be a consideration in any decision making if we're going to be a colorblind society, which sadly the Democrat Party now rejects. Dr. Martin Luther King, as we pointed out with our previous interview with Senator Johnson. This case was brought to highlight the racist policies of left-wing universities, but this ruling is going to have a much larger impact on the society writ large, is it not?
Chris, it's really interesting. I've been thinking about the last 4 hours, right? And like, think about diversity, equity, and inclusion. Think about what Hollywood is doing. Think about the employment laws. You know, under employment laws, you can't discriminate on the basis of color in job applications, right? So again, what we're seeing here is something that we're not seeing normally with jobs. And when it comes to diversity, equity, and inclusion, what we're being told is that spots need to be set aside for comedy writers, no matter what job it is. It has to be equitable. And what equity means, it has to be pursuant to the percentage of the population that you represent. So given what we just saw today with the Supreme Court, you can see how even diversity, equity, and inclusion seems to me a very strong argument. Wait a minute, you don't really mean that you're setting aside categories just for people on the basis of race. The Supreme Court just said you can't do it for college. If you can't do it for college, why are you doing it at my company?
Absolutely, absolutely. And you know, we call it the DIE program, diversity, inclusion, equity. We don't just for your own edification there. You know, our mutual friend, Alan Dershowitz, Professor Dershowitz, this week he had commented, the New York Times confirming, by the way, they tried to bury the lead that the failed Supreme Court nominee, Merrick Garland, lied under oath when he said the U.S. attorney investigating Hunter Biden had complete authority. He didn't. His investigation was stopped by the DOJ. And so Professor Dershowitz says, well, the presiding judge in this case, Mr. Rosenbaum, should basically reject the sweetheart plea deal that was given to Hunter Biden in light of these revelations. The Department of Justice interfered in the investigation. Do you think that's appropriate?
I think Alan's right. I mean, the plea is tainted, Chris. It's a tainted plea. What we now learned, first of all, Merrick Garland said I didn't interfere. We have whistleblowers and FBI informants who are saying, are you kidding? Search warrants were blocked. Interviews were blocked. There was all kinds of stonewalling in order to overcome the statute of limitations. All kinds of things were done to protect Hunter Biden and his father, according to the whistleblower and the informant. And if they're telling the truth, that just suggests that this plea, the Justice Department clearly declined to indict what was possibly much more serious criminal wrongdoing, right? There were charges that just got swept under the rug. It smacks of fundamental unfairness, unequal treatment of justice. A lot of Americans, Chris, you get a letter from the FBI, we all freak out, right? Except for the Bidens. The Bidens don't freak out when the FBI comes calling. When the IRS, when the IRS comes calling, all of us are panicking. And it just seems that here's a situation.
Well, you were right in both instances. IRS, FBI, DOJ, it's the Democrat Party's IRS, the Democrat Party's FBI, the Democrat Party's DOJ, and that means that at least, over half the country shouldn't be funding it. Professor Rosenbaum, thank you very much, sir. I appreciate your time here on the Chris Salcedo Show. Coming up, public